When new people come in, act like you can't hear anything weird.
Hello?
They both do it.
Use them both together, they cancel each other out.
I can't tell if there's a voice modulator on it, or if this is how it's supposed to be.
Just leave it.
There is. Mixer board. Well, I mean, we're not using that.
Just leave it.
Does anybody know how to work a mixing board? Because I don't.
No. Jackhammer.
It's wonderful with stuff like that.
I saw Benny like 2 minutes ago.
Yeah, I saw Benny too. I think Benny's responsible for this.
Just leave it.
Oh my God. This is gonna be distracting.
He's got a new toy.
I'm Dragor, and I'm the biggest idiot ever. I'm Alkali. Howdy.
Spot on impression.
Yeah, I would enjoy not sounding like this.
I don't know, that's pretty good.
It is, isn't it?
You're in witness protection. They will.
No, like honestly, I would have loved this if was. And now, class, we're going to talk about Marbury versus Madison.
Are you sure the other mic's doing it too?
Try the other one.
You tell me.
Yes.
That one's like more milder.
It's milder, but I still sound like a...
I'm still curious.
It still sounds like my mom fucked a Cuisinart, doesn't it?
I'm still curious. Both at once?
I should ask, are there minors in the room? Okay. The good thing is a lot of this panel I actually don't use the mics for because I move around a lot and they get in my way. But yeah, please fix that because the next panel I use the mics for.
Try. This is a test.
Hello?
No.
Welcome to Boozy Does the AV Job. Hello, everybody. Hello. Welcome to Basic Law for Idiots. Yes, I know the panel name's problematic. I thought of it like 2 seconds after I hit submit. I'm not sitting behind there because the way we do this is very simple. We're going to do this more in a Socratic method. All right? Who knows what the Socratic method is? One person in the back. What is the Socratic method? He says as an example of the Socratic method.
All right, questions.
Method where the teacher, professor, whatever, asks questions pretty much exclusively rather than using conventional lecture form.
Exactly. That is how you learn law in the United States and through most of the world. It was established at Harvard Law by Dean Widener. Okay? I did not go to Harvard. My father went to Harvard. My father informed me that when he was getting his campus tour as a fresh 1LE, baby law student, first year, the gentleman pointed at this and said, "This building here is the Widener Law Library. It was named in memory of Dean Widener, the inventor of the Socratic method in law school. May he burn in hell." My name is John Tabler. You know me as the Boozy Badger more than likely. I'm a licensed... It's okay, it just caught me by surprise. I am a licensed attorney in the Commonwealth of Pennsylvania. I'm licensed to practice in front of all state courts in the Commonwealth of Pennsylvania, all federal courts in the Commonwealth of Pennsylvania, the Third Circuit, and I'm considering admission to the U.S. Supreme Court, but let me explain it before you get like, the Supreme Court. Like it's $300 and you just show up and they swear you in and then you have something pretty to put on the wall. Okay? There's like 20 people in the United States who actually practice in front of the Supreme Court, and I am not one of them. All right? The purpose of this panel is very simple. It is to teach you basic legal principles. What do I mean by that? Well, first of all, I am not giving you legal advice. Law in this country varies from jurisdiction to jurisdiction. I am likely, unless you are from my jurisdiction, not licensed to practice in your jurisdiction. You will need to talk to an attorney in your jurisdiction after paying them a retainer amount of their choosing. That is how you retain a lawyer. What I am doing is talk about just general legal principles that we hold up. All right? It's not a question and answer type of thing where you're going to ask me about this or that. They're very basic concepts. All right? Every time I do this, I say we're going to do a little criminal, we're going to do a little civil. Here's what ends up happening. I talk about criminal for way too long and you get like one civil thing. What do I mean by criminal and civil? Criminal law is criminal law. You know what criminal law is, right? God, I hope you know what criminal law is. All right, civil law is literally anything that's not criminal law. Okay? It is family law, it is contract law, it is probate law, it is custody, it is adoption, it is guardianship, it is trademark. Criminal law is you broke the law. All right? How many people in here have been charged criminally with something? Do not raise your fucking hand. How many people in here actually, honestly, have been in court for something before?
Just testifying.
Okay. Not testifying. As a party. I'm not going to ask. I just want to know. Did you have an attorney?
Yeah,
Did you like your attorney?
very much.
Wonderful. I like to hear that. Did you have an attorney?
Nope.
Okay. Why? I'm just asking.
Traffic is just a township.
Traffic? Yeah. Yeah, I won't suggest you hire a lawyer for a traffic matter. All right. So the way we're going to teach is I'm going to talk about concepts. I'm going to ask you questions as we're going through. I'm going to listen to your response. I'm most likely going to tell you that you're wrong. Okay? Don't worry about it when I say it. Don't get offended. That is literally how we teach law in the United States. You walk in, you read a case, you sit down. The professor looks at you and says, Mr. So-and-so, could you describe the holding of this case? And then you talk and they go, and what does that mean? And then you respond. And they go, that's an interesting interpretation. What about this? What if this was the facts? What if that? And the idea is to get you thinking about the law and how it's applied. And you're wrong 90% of the time. Okay? So let's start with the criminal factors. You had a traffic ticket, right?
Yeah.
What were you stopped for? If you're comfortable saying.
It wasn't stopped, but rather it was a driving too fast for conditions after an accident.
Okay. So driving too fast for conditions, you weren't stopped?
No, the building stopped me.
Oh, okay.
Long story.
The building prevented me to move forward. It wasn't the police. Let me ask a question. How many people in here have had a traffic ticket or something along those
I
lines?
haven't
Okay.
been ticketed. I've had warnings.
All right, but you've been stopped by the police, right? Okay. Let me ask you a question. When the police walk up to your car, what's one of the first things they say?
License and registration, please.
What do they say before that even a lot of
You
times?
know why I stopped you.
What do you say?
Nothing.
Right. You know why? At that point, you are making what's called an admission. Right? Do you know why I stopped you today? Nope. Well, I clocked you going 75 and a 55. That's interesting, officer. Don't make admissions. All right, that's the first thing. Because the second you make an admission, it is admissible. Why? And I'll have people say, well, they didn't give me Miranda first. Who knows what Miranda is?
Right.
What's Miranda? Right there.
You have the right to remain silent. Anything you say can and will be handled in constitution of support of law. You have a right to an attorney. In case you can't afford an attorney, one will be presented to you.
Okay. What you're getting at is a case called Miranda v. Arizona. It is, how long, by the way, just out of curiosity, how long have the police been required to read you Miranda warnings?
85?
Is that a trick question?
No, it's not a trick question. It's an honest question. How long have the police been required to advise you of those rights?
The 80s?
1971.
Miranda v. Arizona is less than 50 years old. It was a United States Supreme Court case. A gentleman was stopped by an Arizona patrolman. He was taken into custody. He was asked questions. He responded to those questions. They were used in court. His lawyer came back and said he was never advised of his rights. Therefore, his confession should be suppressed, which is a legal term saying you can't put it into court. This went all the way up to the Supreme Court. All right? Why is that such a big deal? Because the Miranda rights are based on your 4th, 5th, and 6th Amendment rights. Right? Amendment meaning the Constitution. The United States Constitution guarantees those rights. The rights against unlawful search and seizure, that's the 4th Amendment. The right against self-incrimination, and that's the 5th Amendment. Your right to counsel, your right to a fair trial, and your right to confront witnesses, that is your 6th Amendment rights. Now, there's a lot in these amendments, and there's a huge body of case law, but that's the basics, okay? 4th Amendment, search and seizure. 5th Amendment is your rights against self-incrimination. 6th Amendment, your right to speedy trial, counsel, and to confront witnesses offered against you. Now, up until really the mid-20th century, Well, I shouldn't say the mid-20th. 1800s really is when they put it into effect, but the mid-20th century, early 20th century is when they did it. You had those rights on the federal level. If the Federal Bureau of Investigation put you in handcuffs, you had every single one of those rights. There was no question it was a federal matter. It was unclear whether you had them on the state level or not, though. Because despite the 14th Amendment, the 14th Amendment took all of the constitutional rights they have and said, okay, they don't just apply to the federal government, they apply to the states as well. Before that, your constitutional rights only applied on the federal level. The states didn't have to give you any fucking rights if they weren't already in the Constitution. 14th Amendment brought it in, put them there. That's why you hear things like civil rights claims, because the 14th Amendment was part of the Civil Rights Acts. All right, they're called 1803 actions. Those are 1983 actions, I'm sorry. Those are the claims you bring when somebody violates your constitutional federal rights. Normally the government, because, please say it with me, constitutional restrictions apply to the government. They do not apply to Bob. Bob does not have to tell you you have a right to counsel before you talk to him. Bob is not the fucking government. Where does this keep coming up?
Free speech.
First Amendment rights are rights against government intrusion. Okay? Government intrusion. That's all I'm going to say on it right now. So those are fairly new rights criminally when you come down to it. When do you have to be read your Miranda rights?
When you're arrested.
When charges are pressed.
Then you're actually placed under arrest.
Well, I'm hearing when you're arrested. I'm hearing when charges are pressed. Who thinks you have to be read your rights when you're placed under arrest? That's okay. There's no really wrong answer. I mean, there are, but...
I admit, I don't know.
Okay.
And they slap the handcuffs on you.
When they slap the handcuffs on you. So that's... You're the closest, actually.
When you're officially detained?
There you go. That's the answer. It is not when you are arrested. It is not when charges are brought against you. It is when you are detained. When are you detained at law? Yes?
When you are brought in for questioning or they need to put you into the jail cell for a bit.
Who thinks that's right?
When they say they're detaining you.
When they say they're detaining you? So only if they say, "Sir, you are now detained!"
Anytime you can't leave of your own way.
Right there. That is the standard. You are detained for the purposes of Fifth Amendment right, or for the purposes of Miranda, when you are in custody in a custodial environment in such a manner that you are not free to leave of your own will. Right? That is detainer. That is being placed into custody. That is what triggers your right. If you're just... now there's another one, though. So they put you in handcuffs. They don't read you your Miranda rights. Later, you're taken into an interrogation room. You're sat down. The police look at you and they go, "So, did you shoot him?" Does that violate your Miranda rights? They've never read them to you at that point. Does that violate them?
If you don't answer no, but if you answer yes.
No, it's implicated right there. All right, they've asked you that question. Now, if they say, "So what's your name?" do they have to read your Miranda at that point? No. Here's the standard. Only if your rights are being implicated, only if it's a situation where asking that question would get a response that would serve to implicate your Fourth, Fifth, or Sixth Amendment rights, do they have to read your Miranda. You can be arrested and not read Miranda. You can be placed in a jail cell and not read Miranda. The cops can ask you questions. Where do you live? What's your name? That will not implicate your Miranda rights. The second they ask you a question that the answer could tend to incriminate you, that's when they need to read your Miranda. That's when they have to say that. Okay? Rule of thumb, any incriminating question they ask you that is given a response prior to Mirandizing cannot be used in court. What if they say, "What's your name?" and your response is, "I shot him," because they haven't read your Miranda, right?
That's just,
Then you
that's
claim
just
you're right.
openly admitting a crime.
Is it?
They haven't read your Miranda, they asked you a question, you responded. Can that be thrown out?
Maybe.
You didn't answer the right question.
He didn't answer the question. You made what's called a spontaneous utterance in response to a non-incriminating question, completely allowable under Miranda. Now, say there is a shooting in a school area. All right? They can't find a gun. They're pretty sure you did it. They take you into custody. They don't Mirandize you. They put you in the back of the car, but they don't ask you any questions. As they're driving you to the police station, they say, knowing that you have children, like I do, who are sitting in the back of the room watching me do this, say hi. Say my dad's boring. Knowing you have children, driving down the road, the two police officers in the front of the car, they're not talking to you, they're talking to each other, say, man, it'd be a shame if one of the kids in this area found that gun, picked it up, and shot their little brother. Man, we should really find that gun. A lot of schools in this area, a lot of kids walking around, one could find that gun, hurt themselves, hurt someone else by accident. And in the backseat you go, okay, man, I don't want no kids to hurt themselves. The gun's in the dumpster behind the playground. They didn't ask you a question. Is that admissible in court? No. That is the fact pattern I just gave you. That's an actual case that was decided by the United States Supreme Court. The police knew what they were doing. While they may not have directly addressed you, they knew that they were preying on your emotions and asserting undue influence on those specific emotions to get a response out of you that would be incriminating. They were trying to find a way around Miranda. Do I have police officers in the room? Any cops, any law enforcement people in the room? Cops fucking lie! I say that from a place of love. I have police officers in my family. My brother-in-law is a police officer. He's a very nice man. However, I will tell you, I have frankly looked at him and said, cops fucking lie. And he's like, yeah, we do. The thing is can the cops lie? Yeah, say the police bring you in. They're sitting you in an interrogation room. They're like, man, just own up to it. You know, we searched your house. We found the drugs. We know you're the drug trafficker. Own up to it. And you're like, oh, shit, they found the drugs. So you're like, yeah, okay, it was me. All right? Because they found it, right? Why wouldn't you? You get out, you find out they never had a search warrant. They never searched your house. They never found any drugs. They just fucking told you that to get you to respond. Is that okay?
Yeah.
The police can lie to you.
It's like asking.
The police are explicitly, police are allowed to use deception to get a confession from you. All right. I'm talking about the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and Miranda when the police are with you. So you know at this point that a lot of your rights, they don't really come into play. Like Miranda, that comes into play when you're in custody. Somebody earlier said when you're detained, though. Remember that? Somebody out there, when they come to play, when you're detained. And you were kind of right. And the reason you're kind of right is that's when your Fourth Amendment rights come into play. When you are detained. Now, your Fourth Amendment is your right against unlawful search and seizure. Okay? If they put you in handcuffs, is that the Fourth Amendment? Why not?
You could run away.
You're shaking your head. Why do you believe the Fourth Amendment doesn't come into play if they put you in handcuffs?
Well, you could have a weapon on you, so they have to search you anyway.
That's not necessarily it. Yes?
They're not searching you or seizing any of your property.
Ah, they're seizing something though, aren't they?
They're seizing you.
They're seizing you. That is the Fourth Amendment in action. They are seizing you. You are the thing being seized. The Fourth Amendment comes into play anytime you have a legitimate privacy interest and the thing searched or seized. Legitimate privacy or liberty interest in that thing. Okay? So say the police, you've stolen a car. And you're in that car, and they stop you, and they search that car, and they find a shit ton of heroin in the trunk, and they don't have a warrant. Have they violated your Fourth Amendment rights?
They didn't take it yet.
Do you have a legitimate privacy interest in a stolen vehicle? No. You cannot have a legitimate privacy interest in something that is illegal in nature. Legitimate is a key term in that. That, once again, is a pattern of facts from an actual case. All right? Say they see your bank, they think you're laundering money, all right? And your banker or accountant comes in to visit you in the office. He leaves. He has a briefcase. He stops at a cafe. He puts the briefcase on the table, goes to the bathroom, And the federal agent walks up, takes the briefcase, takes it outside, pops it open, finds a bunch of financial records, takes them out, takes them over, scans them in. They find out you're laundering money for a drug cartel. You are arrested and convicted. Has there been a violation of the Fourth Amendment?
Yeah.
Really? Why?
They have a right to just come over and just take some random guy's stuff.
But it's not yours.
But it
It's
violates the
accountant's.
accountant's rights.
Right back there. You're right. They don't have a right to take that random guy's stuff. You're right. It's not yours. You're right. The accountant is the one who has the privacy interest, not you. It's the accountant's property. The accountant is one with the legitimate privacy interest. You are not. So when does the Fourth Amendment come into play? You have a legitimate privacy interest in the thing being searched. That legitimate privacy interest belongs to you to assert. You have no legitimate privacy interest in someone else's house. You don't. It's someone else's house. All right? There's something called the guest rule. The guest rule is if you're just a guest, you don't have any privacy interest that can be asserted. Now let's make this a little more applicable. We're in a hotel. You have a room. Can the police just come in your room and search it without a warrant?
No.
Why not?
Because it's the hotel.
Believe it or
The
not,
hotel's permission.
believe it or not, there is a question in law about that. Generally, the answer is no. They treat hotels as almost like temporary homes. Okay? While you are in a hotel room that you have rented and you are paying for, you have a legitimate privacy interest in that hotel room. So the police cannot just come in. However, say the maid comes in and sees your collection of heroin on the bed, and they call the police, and the police call a magistrate, and a magistrate issues a warrant. Is that a course of events they can use?
Yes.
Yes.
You're right. The maid has every legal right to be in that room. Plenty of case law on it. And people who have been in an area can provide that information to the police, and if they're deemed credible, can be the basis for a warrant. Which I should back up real quick, just say the Fourth Amendment explicitly concerns one thing. When do the cops need a warrant? Okay? That's the question. When do they need a warrant? They need a warrant when they have probable cause to believe that something criminal in nature will be found or somebody should be seized. And probable cause is much more than we think it happens. It's we've got a pretty good set of facts that indicate it happens. And the process for getting a warrant would be the police go out there, they present all this information to a magistrate or a judge. Okay, a magistrate's just a fancy word for a judge. The magistrate hears the information, says, yep, you have probable cause. They sign the warrant. The police go, they search the thing being seized. That's what's going on. All right, so that information, say you have drugs in your room at this convention. Please do not tell me you have drugs in your room at this convention. You have drugs in your room at this convention. Your maid goes into the room. They are allowed to, by law, plenty of law, saying you cannot bar a hotel from popping open the door and at least doing a cursory check around the room daily to make sure there are no safety hazards as part of the hotel's duties. Maid sees drugs. Maid leaves, reports it to the GM. GM calls the police. The maid gives a statement. The police take the warrant. They give it to the magistrate. The magistrate signs off on it. The police come. They say, we have a warrant. They enter the room. They find the drugs. They place you under arrest. Completely legitimate course of events. Say the maid, every 6 months, gets money from the cops. Like the police are like, hey, we're going to give you $50 every 6 months. Maid is not a police officer. Maid is not the government. Remember, these rights only apply to the government. There are restrictions on what the government can and cannot do. But outside of that, outside of the maid, getting $50 from the local police every month is kind of a thank you for telling them when things are going on. Same set of facts. Is that a violation of your Fourth Amendment rights?
Yes.
Why?
Because the maid is receiving government-based funding.
The maid is an agent of the government. Okay? Which brings me to the next point. Your constitutional protections, the restrictions on what the government can do, does not only extend to the police officer. It doesn't only extend to the Department of Justice, the presidency, the governor's office. It extends to anybody acting on their behalf as well. Not acting to help them, but acting on behalf of them. Classic example, the one I love, Batman. Would you like to know why Batman's the worst thing to ever fucking happen to Gotham City?
It's a vigilante.
It's not that he's a vigilante. If Batman was doing this and wasn't working with the police at all, wasn't acting in concert with the police, period, then every single person he arrested, every piece of evidence he sent to the police would be admissible in court. You know why it wouldn't be currently?
Because he's in communication with the...
He's got the spotlight.
You want to know the one piece of evidence that would make everybody say, this son of a bitch is an agent of the cops? The bat signal. The police turn it on when they need him. You gotta tell me he's not an agent? Now what happens when they get into court with that evidence? We turned on the bat signal, Batman went out, but he's not a police officer, so he doesn't have to worry about these constitutional protections. And we're allowed to take information we receive, even if it's illegally obtained, by the way. Somebody breaks in your house, a burglar breaks in your house, and they find that you're running a child sex production ring out of your basement, and they call the police and provide the police with evidence of that. It does not matter that they broke into your house, that the burglar broke into your house and found this. The police can use illegally obtained information from an independent third source as the basis for a warrant. Okay? So long as they're not acting with the imprimatur of authority as an agent of the police. Batman's sent out there, he breaks in, he finds this evidence, he arrests the guy. He has now broken and entering, so he's violated the Fourth Amendment. He has searched and seized property, and he's searched and seized a person, and he's left it and called the police and said, come and get him. I got all the evidence you need here, come and get him. Guys, I'm going to do something called a motion to suppress, and the Joker's back out on the street within a day.
That's only because of the bat signal, though, right? They have.
There's more to it. The bat signal is the single biggest piece of evidence. That's the point that I point and go, Your Honor, they have a fucking spotlight.
That's bad, but they're not actually paying him anything.
Doesn't matter.
He's still working.
Does not matter if you pay or not. If you're operating with the approval and authority of the police, you are considered to be a member of the police for that purpose. All right? Sorry about the limping. I'm normally much more agile and moving around during this one, but I was in a car for 20 hours, so we're just going to hope this table doesn't collapse under me.
I actually had a friend who was acquitted on a Fourth Amendment violation.
Well, let me ask very quick. All right? And this is much more practical. Look, I'm going to shift to civil right here in a moment, because really those are the big three you need to know criminally. All right? You have the right to a speedy trial. You have the right to have an attorney present, everything in Miranda. All right? You have the right not to incriminate yourself. Let me ask a question real quick. If the police take you into an interrogation room and they ask you questions, we all know Miranda from TV shows. Anything you say can and will be used against you in a court of law, right? And you say nothing. You sit there and you stare at them silently. In court, can the prosecutor say when he was asked if he committed the murder, he said nothing? Can they use the fact that you did not say anything against you in court?
Yes. Contempt of...
You say yes. Why?
Because you need to actively enact your Fifth Amendment rights.
Right there. The Fifth Amendment right is a positive right. That means, strangely enough, to say, I am going to use my Fifth Amendment right to not say anything to you. I am exercising my right to remain silent. You can't remain silent. When they say, did you kill him? You have to say, I'm going to assert my right to remain silent, officer, and then you shut the fuck up. If you say that, they cannot use the fact you remained quiet in court against you. All right? The fact that you assert a constitutional right cannot be used against you as long as you assert that right. What about your right for counsel? You have to say, I want a lawyer. Okay? What if you say, if you think I did it, I want a lawyer? It's an affirmative assertment of rights. That means it has to be clear and unequivocal. All right? There's a case. I shouldn't have even said it was a case. I should have asked you this first. A young man in Louisiana was arrested for a rather heinous crime. And while he was being questioned, he said, I didn't do it, and if y'all believe I did it, you should just give me a lawyer, dog. Alright? The police did not give him a lawyer. They continued to question him. He ended up confessing. When it went to court, they tried to throw it out, saying he asserted his right for a lawyer. It went up for appellate review. Alright? The higher court looked at it, and per curiam said, now per curiam is, we're all in agreement, we don't even really need to hear the argument. Said, no, that was not an affirmative assertion of the Sixth Amendment rights. One asshole judge on that court decided that even though he didn't have to write an opinion, he was going to. And he made light of the fact that the statement was unclear because it could be interpreted as the gentleman asking for a canine attorney. A, that judge is a racist. I just want to throw it out there because everybody in this room knew that is a colloquialism, right? That is just a phrase you use. He was not asking for a canine lawyer. He was using the patois of the area he grew up in. That fucking judge is an asshole and probably a racist. B, when everybody lost their mind about that opinion, they lost it for the wrong emphasis. The decision was not based on lawyer dog. The decision was based on if you think I did it. If you think I did it is not a clear and unequivocal expression. There are many cases that hold that way, that you are asserting your right to an attorney. Don't do that. If you ever find yourself in that position, not, I don't believe I want to say anything to you, officer, that is not a clear and unequivocal expression of your rights. I think I may want a lawyer. That is not a clear and unequivocal expression of your rights. Be clear. I am not going to talk to you. Or better yet, I am asserting my Fifth Amendment right. Please don't assert your First Amendment right to the police. I want a lawyer. Those are the only two things you need to say. And at that point, they should stop fucking talking to you. Especially when you say the second one, I want a lawyer. Now they can like walk in, hey, do you want a sandwich? Hey, do you want a soda? All right, they can do all of that, but they can't ask you anything about what they're investigating at that point that would tend to implicate your criminality or innocence. All right, and it's important to you that after you say that, they say, man, and they can do exactly what I talk about, or they can sit there amongst themselves, man, really sad that family's never got to know where the body is. Don't say, yeah, well, I don't know where it is either because I didn't do it, because now you've waived that fucking right again. Keep your mouth shut, wait for a lawyer. That simple. All right? When does it come into play? When you are detained. Okay. So the police stop you. All right? They come up to the car. You do the smart thing when they ask, do you know why I stopped you? You say, no clue. You like the color of my vehicle? Like, you heard I stopped at Krispy Kreme? What's going on? You give them your license, your registration. You keep your head throughout the entire encounter. At the end, the police officer hands you everything back. All right? He turns around. He starts to walk back to his car. He turns back around and says, hey, one more thing. All right? Now, there is a Supreme Court precedent out there that says the police cannot detain you when they stop you like that. That is a detention, by the way. You are not free to leave. That is the question for detention. Are you free to leave? Before, when I was talking about being placed into custody, it was, are you in custody? Are you in a custodial setting where you know you're not free to go? Detainer is, you are not free to go. A traffic stop is a perfect example. When the cop stops, he says, do you know why I stopped you? You can go, nope, bye, and just fucking zoom off. You're not free to leave. Okay, now if the cop stops you on the street and says, hey, do you live in the neighborhood? You can go, and just keep walking. That's what we call a consensual encounter. It is not a detainer. And the police do that, by the way. They will walk door to door. We're in the area. We just went to introduce yourselves. We're the new patrol officers. We want to see if you had any thoughts. This happens. It's called a knock and talk. Okay? If it ever happens to you, A, keep your cool. B, maybe don't open the fucking door. There's nothing saying you have to. C, watch what they do. Because when you open the door, they do this. So we're just in the area where the new police patrolman want to know what your thoughts were about crime in the area. You know what they're doing? They're looking behind you. Because one thing that an exception, an exigency to the Fourth Amendment where they can't come into your house without a warrant is called the plain sight doctrine. The plain sight doctrine says anything that is plainly criminal in nature that you can perceive in an open area using only the senses God gave you will obviate the need for a warrant. So if you open your door and you're in an area where marijuana is not legal, and they find and they see behind you a lot of marijuana on your coffee table, the police can go, well, we're coming in now. And you're going to say, do you have a warrant? And they're going to say, we don't need one, man. And they don't. Because they are charged with the seizure of things of a plainly illegal nature. They can walk right the fuck past you into your house and take it. That justifies not waiting for the warrant. Yes?
What happens if you open the door, they see a bunch of rolling paper on the table, and they just investigate that? It's tobacco, but while they're there, they see something else.
That would be unlikely. Just the presence of rolling paper would be unlikely to do it. The reason is it's why I said a plainly illegal nature. If the cops look at my car and they see rolling papers, they may think this guy's got weed in the car. And that may lead to what we call reasonable suspicion. All right, reasonable suspicion is a much lower standard. Something called a Terry stop. It's from Terry v. Ohio. A Terry stop is a temporary detainer. Temporarily, you are not free to go while the police investigate a reasonable suspicion of criminal activity. They are only allowed to detain you long enough to confirm or deny that reasonable suspicion. So if the police stop me and they see rolling papers in the car, maybe they say, well, maybe this guy has weed in the car. Normally, in our experience, people with rolling papers in their car aren't smoking cigarettes. They've got weed in that car. Okay? That may justify a Terry stop, which means they can only take a look in certain areas, like a Terry stop. They can't put their hands in my pocket. They can certainly pat my pockets. All right? Generally, they say, well, we're looking for guns. But if during that they feel something of a plainly illegal nature, a good example, I really shouldn't ask this in a public forum. How many of you know what a crack pipe looks like? A lot of you know what crack pipes look like, and that worries me. There are types of drug paraphernalia that have very distinct shapes, and they're not used for fucking anything other than smoking those drugs. If the officer were to feel something like that in there that has a very distinct shape and is not used for anything but the legal thing, that could justify further stops. That could justify more than just a Terry stop, okay? But generally they can ask you a few questions. The moment they stopped you long enough to confirm or deny the suspicion of criminal activity, they got to let you go. They can't keep you longer. Now that kind of feeds into the traffic stop. Let's say you're stopped, the police come up and they say, we're going to call K9. They see the rolling papers. They say, we're going to call K9, man. So you might as well tell us if anything's on the car. All right? And then you're sitting on the side of the road for 30 minutes waiting for that K9 unit. And the K9 unit indicates they see or they smell marijuana in the vehicle, and the police use that as reasonable suspicion to search your vehicle. All right? I should say, first of all, in almost every state, vehicles have a much lower level of Fourth Amendment protection. Okay? It's not always indicated that they're going to need a warrant to search your vehicle. All right. You can, many times, if they stop in something like that, they can at least search the cabin of the vehicle. They may not be able to open a locked trunk. You have a higher privacy interest in a locked trunk. But they can generally search the cabin of the vehicle on reasonable suspicion once they have enough to justify it. The whole purpose of the K9 unit to sniff out drugs is to get the reasonable suspicion to justify the search of the car. So you're there 30 minutes, they bring up the K9 unit. The K9 unit indicates they search the inside of the car, they find marijuana, they place you under arrest. Is that search going to be thrown out?
Not if you weren't asking to leave.
Yes.
Well, no, you're being detained at that point. They've detained you legally.
But only for so long.
Yes.
There you go.
Because they had no
Only
reason
for
to
so
call the
long. The
K9s.
Supreme Court has ruled that the police in a traffic stop situation cannot detain you longer than is reasonably necessary to complete the traffic stop. If the normal time for a speeding ticket is 10 minutes, and that K9 unit can't get there in those 10 minutes, they got to let your ass go. Because that keeping you over takes a lawful detainer into an unlawful detainer. How do they get around it? They give you your ticket, right? They turn around, they walk back to their car, back to what I was saying earlier. They stop, they turn back around, they go, hey, one more thing. And in that conversation, they say, I noticed rolling papers in there. You got any weed in the car? And you answer. Then they call K-9 unit. They say, well, I'm going to call K-9 unit. You don't mind, do you? And you answer. They call the K-9 unit. The K-9 unit points. It's 30 minutes after they stopped you now. They search the car. They find marijuana. You are arrested. Will that be thrown out of court?
No, that's two separate things at that point.
And you agree to it.
Right there. It is two separate stops. There is case law indicating that the moment the police have handed you your ticket, the detainer is done. You are free to go. If they stop on the way back to the car, turn back around and engage with you again, and you choose to engage, now it is a consensual encounter. You have chosen to engage with the police. So what do you say when they turn back around? Hey, I smelled some marijuana while I was up there. What do you say?
Have a lovely evening.
Have a lovely evening. Am I free to go? My personal favorite, and I actually have like dash cam video of one of my clients doing this, was, that's weird. So I'm going to go now. And like I called that client, I'm like, you are the smartest one I've ever represented. I smell marijuana. That's weird, man. By the way, they always smell marijuana. I don't know what it is. It must be something in the water in America. But our police have super senses because they can smell pot through like an entire vehicle in a locked trunk in a metal case surrounded by potpourri. And I'm like, I smelled the marijuana in the back of the car. Fucking Justice League. So that's your criminal law primer. Let me get into, real quick, the civil law primer. Everybody look at the back of your badge, because we have 15 minutes left. Look at the back of your badge. If you're smart, you are identifying the words on the back of that badge that matter to me in something called Basic Law for Idiots. What are those words?
You agree to the code of conduct.
How many of you read the code of conduct? I hate all of you. There's like 3 hands up. What is wrong with you? Nobody. It's available. Look at their website. The code of conduct is available on their website. It is something called, in this case, it'd be somewhat different. This is more of a shrink wrap agreement. By use, you are agreeing. Okay? The case out there that does that is Pro CD, is kind of the leading case they teach in law schools about that. All right, let me ask you a question. You buy a piece of software, the terms and conditions are not on the box. Okay? You open the box, the terms and conditions are inside, and it says by opening the box you have agreed to these terms. By opening this box and using this product, you have agreed to these terms and conditions. You've already paid. It is already yours. You were not aware of the terms and conditions when you purchased it. All right? You install it, you use it. You use it in a way that exceeds the terms and conditions that you were not aware of when you bought the product. Is that enforceable?
No.
And let's say, let's go even a step further. Because you just said you installed it. Let's say the terms and conditions aren't even in a paper form in the box. You can only read them when you're installing it.
I thought there was a precedent where things written in the terms of service for software where you go down and click accept and continue were thrown out because...
No.
Oh.
What you're getting to is something called click wrap, and I'll get to that. Shrink wrap agreements and click wrap agreements are agreements that you cannot be aware of the terms of until after you've already purchased the product. Okay? Generally, they are enforceable. As long as you have a chance to read them within a reasonable time after purchase, and something that you can do to deny those terms and conditions. Generally in court, that has been returning the product. If you don't agree, you return the product. Now, say you bought it from GameStop, you don't agree, and you say, well, it's open, so we're not going to give you your money back. If you look at the terms and conditions, many times they will have like a denial thing that will say, if you don't want to agree to this, and it's within so long after purchase, call us, we'll buy it back. And they'll say that, call us, we'll buy it back from you. Now, nobody ever does it. I'm just telling you, nobody does it. Everybody does it. Now, say you install a game and it says go to our website to read our terms and conditions, and there's a link to the website. Is that enforceable?
Besides that, an ongoing service, say an MMO, does say they change their terms and conditions after.
Not only an MMO. Let's say you bought Resident Evil and you install it, and then there it says by playing this game you agree to our terms and conditions, and there's a hyperlink right there. Is that enforceable? It requires you to click through. Yes.
I don't think it would be, because that would be implying that the individual who purchased that game has the ability to review the terms and conditions online, right?
That would be one. That's one interpretation. It's actually an open question, and that is one of the questions, which is, do they have the ability to review this? And that is what you were getting to, actually, which is when you go through them, right? And it says, by doing this, you agree to our terms and conditions. If it just says you agree to our terms and conditions and doesn't tell you where to find them, probably not enforceable. Probably not enforceable at all, because terms and conditions have to be something that you can actually read to do it. If they put a hyperlink in, it's much more of an open question, though, because like you just said, how do you know everybody has the ability to use it online? How do you know they have that ability? And courts really haven't been addressed with that yet. One of the reasons they haven't been addressed with it yet is, you know how much software is now always on? You know what always on is? Always on is it always has to have an internet connection to work. And I'll tell you right off the bat, a lot of times, you have to update it before it'll run and confirm the update by going into the system. That's the way they're getting around that, is they'll put in the hyperlink, and then you say, well, I don't have the internet. I have no way to check it, Your Honor. The publisher will say, Your Honor, they couldn't even gotten to that screen if they didn't have the internet. So obviously they have to take it somewhere with internet connectivity to download this update, which then presents them with that, and at that time they didn't click through. They had an opportunity to read it, which is an important thing that leads into all contract disputes. You don't have to read the contract for it to be enforceable. Okay? Somebody hands you a contract. It is 300 pages long. You do not read it, but you trust the person. You flip through it to the end and you sign it. Is it enforceable against you?
Yes.
Say they know you didn't read it. You don't know what the terms are. You sign it. Is it enforceable against you?
Yes.
Say they hand it to you and say you have to sign this in the next 10 minutes or we're never going to give you this offer again. Is it enforceable against you?
No.
Yes.
Really?
Interesting.
Oh, if you sign it. What consideration had to be?
The court considers an opportunity to read and understand a contract the same as reading and understanding the contract. Right? If they say, if you don't sign in the next 10 minutes, we are withdrawing the offer, the court will say, you should have refused. You knew what the condition was, and you should have refused. When you hear that, what people think is, oh, well, they were pressured into signing it. Guys, if pressuring people into signing contracts were enough to invalidate them, nobody would ever buy a car. Okay? It is not pressure. That is a concept called duress. You signed it under duress or undue influence. That is something that you can use to avoid a contract. To say it should not be enforced against me because I signed it under these conditions. But duress is not just you were pressured to. Duress is almost, and this is the best explanation, the majority of jurisdictions, somebody was holding a gun to my head. I had no choice but to sign this contract. Right? They were going to hurt me. They were going to hurt a family member. They were forcing me to sign it such that it would overcome the free will of any reasonable person. If a reasonable person is given a 300-page contract and said, sign it in the next 10 minutes or this offer is rejected, do you think a reasonable person would go, sure, there you go? No, most reasonable people say, absolutely not, go to hell. How many of you have leases? How many of you have read your leases? How many of you read your leases before you signed them? How many of you did not understand a term in your lease? How many of you told your landlord or whoever handed you the lease, hey, what does this mean? How many of you listened to that person? How many of you then took it to a lawyer? Why?
That costs money.
That costs money.
Friends, you got money.
Let me ask, what's your security deposit? With your rental, what was your security deposit?
$2,000.
$2,000. Right. You have a $2,000 security deposit. Say there's a clause in that lease that says if when you move out you have not repainted and replaced the carpet, we get to take your security deposit and we use it specifically for that. I'm using those two specific examples because generally in most states security deposits cannot be used to repair what they call reasonable wear and tear. Reasonable wear and tear generally tends to include the replacement of carpet and painting. All right, so generally, a landlord, if they try to say, well, we had to repaint the place and we had to replace the carpet and you've been there for a couple of years, a girl will say, that's reasonable wear and tear. You can't collect against them for that. You know, you're repainting and replacing the carpet every 2 years anyways, or you should be. All right? But say if they put that specific provision in your contract, you know what I mean? They say, oh, no, we only do that if you move out within the lease term and it's really damaged. Okay? Now you got $2,000 hanging out there. Something happens, you move out early, right? Say your rent's much less than $2,000 a month. The place is in sparkling clean condition. You say, hey, what about my security deposit? And they say, oh, no, that's gone, man. We used it to paint, replace the carpet, and you forfeited it when you moved out within the lease period doing that. But you told me. It doesn't matter what we told you. There's something called a merger clause in a contract in the parole evidence rule. Okay? Here's the gist of it. A fully integrated contract, fully integrated meaning this contract is our agreement. Outside of this contract, there are no questions that can be raised because the contract spells out the expectations of both parties. Is not subject to any prior discussions, agreements, or considerations before the signing. If somebody tells you, don't worry about that, we never enforce it. You sign the contract a week later, or a day later, or an hour later, or 15 minutes later, and then they sue you for that. And you go, wait a second, they told me that doesn't matter, they're never going to enforce it. They're going to say, parole evidence rule bars that the omission of that evidence. Parole evidence rule looks only at the four corners of the contract. There are ways to overcome it. They're not easy. Any prior discussion or negotiation that is not incorporated into the contract itself becomes void. So in that example, they say we don't enforce that unless you move out. You take it to a lawyer, lawyer's going to charge you like $100 to review a standard form lease. I'm just telling you. They're like, that's what I charge for them at least. Oh yeah, I'll charge you $100 to see if it's a standard form lease. Yeah, sure. And then I'll say, yeah, there's nothing really to be concerned about here. Or if you say, I have specific questions about this one paragraph, I'll read that one paragraph. All right? But at the end of the day, if you don't, and they're lying to you, you're losing $2,000. And that's why I suggest hiring a lawyer. A lot of people will sit there and they'll say, a lawyer's going to cost thousands of dollars. Not for a lot of typical stuff. I'm just telling you, not for a lot of typical stuff. Most of us will say, oh, it's a contract review. Yeah, I'll do it for, $100 an hour. Or, give me a couple hundred, I'll take a look at it. You'd have every single contract reviewed. I mean, I'm always going to say yes. I'm a lawyer. That's what I do. All right. I'm also going to always say yes because I'll have people come into me and they'll say, they're getting a judgment against me for $10,000. I need you to fight this lawsuit. And I'll look at it and I'll go, why didn't you have a lawyer read this? Well, would it cost a good amount of money? I'll go, okay. Well, let me be very clear. The $300 you didn't want to spend 2 years ago is probably going to cost you about $5,000 in legal fees now. Because it's cheaper for me to correct it then than it is for me to fight it now. That's 90% of my contract cases. Who knows what confession of judgment is? I have enough time to go over this. I always love doing it because it's important. All right. You sign a contract. You don't really read it or you don't understand a term in it. But you sign it, you violate it. They send their lawyer to court when they violate it. All right? And one day, you wake up and the sheriff's at your door. And the sheriff doesn't have a lawsuit. What the sheriff has is a piece of paper that says,
we are going to execute upon your property. We're about to levy on it. What's a levy mean? A levy is when the sheriff walks in, they put a tag or they write down a list of all of your items and they say, on this day we're going to sell them at auction to satisfy a judgment against you. You've received nothing else. You've received no paper. You've received no service. You've never heard of a lawsuit. Just one day the sheriff's there says, this guy's got a judgment against you in this amount, and we're going to list all your stuff for sale to satisfy it. Can they do that? If they have a confession of judgment, they can. A confession of judgment is an archaic legal mechanism, is a contract mechanism. In that confession of judgment clause, when you sign the contract, you are authorizing the person you are signing the contract with to hire an attorney to file what is called a complaint and confession against you. They walk down, they file that complaint. At the same time they file the complaint, they file a form that states you are confessing to the nature of that judgment, because in your contract, you have authorized that attorney to confess judgment against you. It'd be the same thing as if they filed a complaint and you filed an affidavit saying, yeah, their judgment amount's right, immediately afterwards. It does not require service of the suit in most places, because there's nothing you can do to challenge it at that level. You have to open the judgment. The judgment is now entered. In my state, Pennsylvania, when you confess judgment against somebody, I have 3 different ways that I can notify you of it. One of them is I have to tell you, hey, we confess judgment against you 30 days before I can send the sheriff out. I don't do that very often. People tend to move to open the judgment and talk about all the reasons they didn't really breach the contract, so the confession's not valid. You know what I do? I use the 3rd way, where I get the confessed judgment, and while I'm standing at the courthouse right after they enter the confessed judgment, I have them hand me a copy of the judgment and a precipice for a writ of execution, which is the court order to the sheriff to go get your stuff. Then I walk up to the sheriff's office, I hand them the writ of execution, I hand them enough stuff to send you things by certified mail, and if I know where your bank account is, I hand them garnishment documents for your bank, and the sheriff goes out right after that and provides it to the bank, and the bank then serves you with everything by certified mail, and that's the procedure that they follow. And you tend to find out when you stop to get gas 2 minutes after the sheriff stopped at your bank and your card's declined, and you call your bank to find out, hey, I've got $1,000 in that account, why is my card declined? And the bank says, oh, we were served a garnishment order today, so we have moved all the money out of your account into a litigation account. And we're going to fill this out and send it back to their attorney saying how much we just moved. And then he's going to file an order for release with the court, and we're going to send that money to that lawyer because you have a judgment against you. And that's 9 times out of 10 when I do them, how people find out my client has confessed judgment against them. If you don't read your contract, you're not going to be aware of that clause. Now, I said it's archaic. It is not a common clause. I use it here more for an example of why you should read your contract and make sure you understand what is in your contract. Okay? Not very many states allow confessions of judgment anymore. Definitely see if your state does, but not very many do them because they are considered an extreme remedy. They are disfavored at law. New Jersey does, New York does, Pennsylvania does, I believe Ohio does, but I'm not exactly sure. Many states have outlawed the confession of judgment process. But you should always read the contract to be aware of what's in it. Extreme remedies, liquidated damages, which mean you have said, doesn't matter how little they lost, I've agreed to this amount of damages as being reasonable. Jurisdiction and venue. I've agreed to be sued in Washington State. They sue you. You live in New Jersey. You say, how can they sue me in Washington State? And they bring out the contract that says the jurisdiction of this contract's Washington State. So bring your ass to Washington or enjoy the foreign judgment that we're going to move to New Jersey right after Washington grants it. Read your contracts. Now, I am out of time for this one. Luckily, I am the next guy in this room as well.
Prolonged class.
As I always say with Basic Law 101, the idea is not to give you a primer of every law in the United States. There is no such thing as the book of law. Okay, it's case law. It's statutes that are written. The idea is to cover two high points. The first one on the criminal side, which I always spend too much time on, as I said at the beginning, because that's the sexy part of law, but the important part is to know those three rights. Your Fourth Amendment rights, your Fifth Amendment rights, your Sixth Amendment rights. Do you all have a basic understanding of what those are after today? The second part is to say, read your fucking contracts. Do you all understand the severity of that after today? Do you all understand that you're never going to be able to recognize these situations without hiring an attorney? Okay. The idea of this panel is not to teach you the law. I can't do that. It is to teach you just enough of the law to recognize when something is so complex that you actually need to get somebody who can do the legal work for you in. Not everything requires a lawyer. I'm not saying that. I'm saying you need to understand when a situation that you may encounter arises that requires one, and you may want to go out and get one at that point. That said, I don't have a robot voice anymore. And I have another panel starting 3 minutes ago. So thank you all very much for coming to Basic Law for Idiots. I promise the next time I do this, I will use the wonderful PowerPoint that I left on the laptop that's sitting at home. I am in this room for Lawyer Horror Stories starting now. So let me walk around to the other side of the table because I need a real chair for this one.
Yes, I do. I just want to stretch my legs.
Silver Gato Man, he bought me a coffee. Silver Gato Man, here is the song for thee. He likes to video all the panels at the cons. You should go and watch them whether they are short or long. Silver Gato Man, you video that's not a jibe. All of you go to his YouTube channel and like and subscribe.